Hi, everyone. I'm Ashley Kappel, and I'm presenting today on the future of law practice management, 6 innovative strategies to outpace your competition. For those of you that don't know me, I can get my slide to connect, click. There we go. Here's a quick bio on me. I've practiced law for the last decade. Before that, I was a teacher and instructional coach and founder and director of a teacher preparation program. And I founded The Modern Lawyer most recently to combine my passions of teaching, coaching, practicing law, and improving inefficiencies into one venture after earning a legal project practitioner certificate from the International Institute of Legal Project Management and an executive coach certificate from the Center for Executive Coaching. So I'll tell you a little bit more about this boot camp that I'm starting at the end. But today I'm going to provide an overview of 6 legal project management strategies that Big Law has been starting to use for the past decade. I'll begin the presentation by explaining what project management is, what legal project management is, its history, and why it's so necessary for solos and small law firm leaders like yourselves to implement this into practice. The boot camp I'm starting will provide a more comprehensive deep dive into all legal project management tools and give members a chance to pilot these strategies into their own practice. So I'll talk a little bit more about that for just a minute at the end. A little housekeeping, this is a 2-credit CLE. I'll try to keep the presentation to 1 hour and 15 minutes to allow for questions at the end. It'll be difficult for me to monitor the chat, so if you could just please hold your questions to the end. So I'm going to start off with the history of project management. It's not new. You see a picture of the Great Wall of China over there. And certainly the last forever, project management tactics and techniques have been used to build things like the Taj Mahal, the Panama Canal, getting man to the moon, and modern jet planes. In 1969, the Project Management Institute was established to share best practices in the field of project management. And project management has been used daily for decades by consultants, accountants, architects, construction workers, but it's only been recently adopted by law firms coming out of this 2008 recession. The definition of a project the way I like to look at it is it's got a beginning, middle, and end, and it has a goal of delivering a unique product, service, or outcome. It should be no surprise to you that all legal matters are essentially projects. So how is like building a custom home like practicing law? So I'll come back to this slide in a minute, but think about this for a second. I've got a friend who's a construction project manager. He oversees large commercial building projects, make sure that everything happens at the right time, in the right order, and at the right cost. He's deeply trained in project management discipline and very good at what he does. Most lawyers would bristle at the idea that their practice could benefit from a dose of rigorous project management. But hopefully what I come to share today with you is you'll start to see that there's a bit of a different focus if you are really truly practicing with a legal project management strategy in mind. So what is legal project management? So there's not really a uniform definition. It's still kind of, it emerged out of as a response in clients asking for greater cost efficiencies, predictability, and better transparencies coming out of the 2008 recession. So a few from the experts: the application of project management principles to enhance the delivery of services, legal services, the discipline of planning, organizing, securing, and managing resources to achieve specific goals related to the control and management of legal cases. At its core, it's about better communication, and it increases client satisfaction and firm profitability by applying proven techniques to improve the management of legal matters. So Big Law has entire positions that are dedicated, they're called legal project managers. some of whom are project managers from other industries, and others who are attorneys. Instead of a senior lawyer managing the project, a legal project manager will manage it from beginning to end. So today we're going to explore ways that you can use legal project management strategies in your practice. So here are some of the benefits of legal project management that research has shown. Differentiation in the market. So if you're not using this, this is something that is cutting edge and you should be using it. Increased profitability and realization. Clients will start to ask for this. They already are asking it of big lawyers, and they're starting to really, as the recession is coming and hitting, they're going to be asking for discounts or some kind of more predictable pricing mechanisms, which we'll talk about more in depth here in a minute. Protect business with current clients, develop new business from new and existing clients, creating predictable budgets and schedules, developing greater value, delivering greater value to clients, and improving client communication and reducing surprises. So we're going to come back to this slide here. So when you're building a custom home, would you do it by the hour? Would you buy a custom home from a contractor who said, I'm going to charge you $300 an hour? Probably not. And so the question is, why can't lawyers be more predictable in their pricing? I mean, there's similar things that come up in construction projects, all the time that make it difficult to determine what a price is, determine what the schedule is going to be, determine what the outcomes are going to be. So you would expect, if you were building a custom home, that the architect and the contractor were all on the same page with you as to what this home was going to look like, that the scope of work was clearly defined, that the schedule was clearly laid out and you knew exactly how long this was going to take to build, that the staffing plan was in order, that there's a budget and a price that's pretty clear. You're not going to go for a house that's between the price of $300,000 and $600,000. And you're certainly going to want to know progress along the way, and you're certainly going to want to know if you make a change or something comes up, there might be change orders that are warranted. And as you go along in the home, project management is a way to manage all of these things, to budget, to make sure everything comes out on time. And certainly you want to use certain systems and processes as a contractor and an attorney to make sure that this gets done. And finally, you'll have an inspection at the end to make sure the client's happy. So similarly, a legal project management framework is very similar to this construction model, and really any project management model at all whatsoever. You've got a stakeholder analysis and in the mobilization phase at the very beginning. Who are the client stakeholders? How do you define client success? What is excluded and included in the scope of work that you're doing for the client, and with what assumptions? And then in the organization planning phase, and by the way, the bolded information on this slide is what I'm going to be talking about today, the strategies I'm going to be sharing with you today. So budget and pricing is obviously incredibly important to clients. Staffing plan, schedule, communication plan, and risk strategy. These are all things you need to plan up front. And as lawyers, we often don't do that. We just kind of launch in, I'm guilty of it too, into the legal issues, and don't set out these metrics and establish all of these things at the outset. And the implementation phase, that's where you're doing the legal work. So tracking and monitoring, negotiating scope changes, just like you would if you were to be a contractor, managing process efficiently, and managing communication of risks and issues. Finally, in reflection, you do what's called an after-matter review, which I'll talk more about at the end. Looking back to see what went well and what could have been done better. So strategy 1, identify what is included and excluded from the scope of work with the client with assumptions. And we're going to break this down and talk about what all of these pieces are. So for a minute, there's a scale called a Likert scale that if you take a minute and reflect, if you disagree, somewhat disagree, or you agree with these statements, any of this ring true or resonate for you? As before we launch into scope, I want you to sort of think about these topics and see if they resonate. I sometimes have challenges with attorneys on my team and our clients agreeing on what is included and excluded in a specific case or transaction after the project has started. At times, I have encountered clients who struggle to know what they actually really want or need. And so you're rating this like, I strongly agree or I disagree with this. When there is more than one client decision maker, they may disagree on the objectives of the representation. My engagement letters sufficiently state the assumptions, inclusions, and exclusions of the cost estimates I have provided to the client. I could better define the scope of the matter in my engagement letters, especially for alternative fee arrangements. And I have had clients contest what I did in a matter on what they are willing to pay for. So this is what's called a cost work breakdown structure. To create a scope of work, you want to use the phases or deliverables or a combination of both. So each legal matter can be broken down and documented. Now, when I read about this, I thought it's not rocket science, thought it was quite interesting, but I had never really thought about breaking things down in this granular of a level to start learning how to price, to tell the client what the scope of work is going to be exactly. So the first level is the project. The second level is the phase or deliverable. And we'll go through an example in just a minute so you kind of get a sense of what I'm talking about. And then the third level is what the activity, task, and components of work are. And you can you can break this down further if you need to. And certainly at the level 3, that's where you estimate cost, time, staffing, duration. So here's an example of something that of a lease update that I just did pretty recently, and I used this same process in order to provide the client with a good cost breakdown of what I was going to do and how much I was going to charge. So first, I reviewed and analyzed. That's the deliverable or phase. And then I reviewed the lease and generated a list of questions for the clients. That's sort of the breakdown of what the actual task was. The next step was communication, review and respond to the phone calls to discuss with the client. Then I had to draft and revise the lease, update it by paragraph, and then send it out to the client for review. And again, this is a very basic example. If you're doing an M&A deal or a acquisition or a piece of litigation, this would get much more complicated, but I just kind of wanted to share the basics with you. Review and analyze again. I would review and analyze the client comments or questions to anything that they read about or anything that I had changed in their lease. And then communication again, have follow-up calls to discuss what the client comments were. And finally, I would make any revisions to the lease for the client comments. So the benefits of a work breakdown structure are they make sure you consider all aspects of the project. They promote communication between you and the client at the beginning of what's to come. They stop work from falling through the cracks. I know when I started to write all this down, I realized that there were things that I wasn't accounting for in my work and wasn't budgeting for, so it was hard to give an accurate budget. reduces the number of changes that you're effectively going to see in the work down the line, and it helps you calculate schedule, budget, and staffing. We'll come back to the same example a little later after I've gone over some of the alternative fees for the project, for alternative fee strategies. And then you can use this again on future projects. You can basically create a template for each type of matter that you do and break it down into different levels of the work breakdown structure. So exclusions, what is out of scope? You need to define clearly what is out of scope in an engagement letter of what the statement of work will not cover. This is not something that I had ever really thought about until I got trained in this. To do that, you've got to really reflect on past legal matters to figure out what you would exclude. And I'll give you an example of this in a minute. It really helps manage client expectations throughout the matter and facilitates easier conversations about scope changes later. So here's an example. If you're a family lawyer, this will maybe be relevant, and anybody could probably relate to this. But if you were to seek an agreement or court order for full custody of a child, that's the example. That's the project, if you will. So here's another work breakdown structure. You've got to draft the statement of the disputed issues on behalf of the mother, engage in 2 hours of pre-hearing negotiations with the father. If that doesn't work, then you're going to be drafting a claims notice and send that via certified mail, and prepare application to the court for consent orders on behalf of the mother, and then finally represent the mother in court to seek that court order. So what's excluded from that? A lot of family law attorneys do what's called unbundled legal services, and this is a great example where the divorce or separation proceedings would not be included in this price if you were to, kind of scope this piece of work out. Expert witnesses would be excluded, and all other family disputes and claims, including any assets, would be excluded. And you would state that right up in your engagement letter. Assumptions are scope carve-outs. Those are used to balance the client and the firm needs. And you really need to balance this between what's needed for self-protection of your own work and also with balanced client relations. They should also be included in the engagement letter. So here's some example assumptions. For transactional attorneys, you want to limit the number of document turnarounds. Like if you're trying to give a fixed fee price, you've got to come up with some kind of way to, some kind of mechanism to limit this. So it's probably 3 times, let's say, that there's going to be a document turnarounds. If the closing date is going to occur after a certain date, then that would be another way to limit this. Then you would charge more. Another thing is a creation of a deal room for due diligence that will be readily available in electronic form. And finally, and then also you want to exclude any risk factors like extended negotiations for later amendments. Those kinds of things would not be included in your original fixed fee. And due diligence issues uncovered in the diligence review process should be excluded as well, because you don't know you can't plan for that until you actually get in there and you see what due diligence that there is. For litigation, you also can do the same thing. Limit the number of depositions, expert witnesses, and consultants to a certain number. Agree on that with your client. Volume of document production requests. Limit that. Local counsel fees, court costs, and expenses are excluded. And certainly creating a litigation deal room where everything is provided up front. I know I've had so many times where I have had a matter come up and the client doesn't have everything ready for me. Well, that's certainly going to cost more. If the client, you're going back and forth with the client, or you have a paralegal going back and forth with the client trying to get certain documents. So if you're trying to be more cost efficient and cost effective, you definitely need to think about the creation of the deal room and making that an assumption of the cost before you set out to establish that. The second strategy is developing a strong communication plan to manage the client expectations. So again, here's a Likert scale. Does this resonate with you? I have wasted time and unable to do my job due to missing documents or information not being provided to me at the outset. I have failed to provide the client's legal team with timely information regarding a change in strategy or new information related to the case. I have overworked an issue and later had to write off time because the client didn't provide me with clear expectations or guidance on the issues on the matter at the outset. I've certainly had that happen to me. I have wasted time trying to catch my client by phone, and each call requires me to review my notes on the matter to confirm what needs to be communicated. I am often anxious when I start a new client relationship and don't like to discuss what could go wrong to impede the new relationship in any way, and have thus avoided discussions about client expectations and objectives at the beginning of a matter before. So communication planning is the key to developing a great scope and to having a matter go really well throughout. I know that my client communication historically has been reactive, and what you want to really try to do is make it more proactive. And this plan should be set out before determining a budget. You want to prevent informal and reactive communication, as I just indicated. And you want to go above what the model rules say in 1.4, which just requires keeping the client reasonably informed from the beginning. So communication planning, I just feel like I'm talking to myself. There's nobody looking at me. This is an interesting presentation. I have not done one of these before where I'm just giving a presentation in my house to myself. So if anybody wants to turn their computer on, I would love to see your smiling faces. So in a preliminary meeting with communication planning, before the meeting, I mean, you want to have these meetings up front before you ever even quote a fee. So before the meeting, you have two meetings, a preliminary meeting and kind of a kickoff call. Oh, some smiling faces. I'm excited to see you. So you're going to discuss the engagement, obviously, and you want to provide a list of questions for the client and to sort of see what it is that, and there's all these questions you can ask, of course, but you want to think about the stakeholders. And during the meeting, you want to define the client success with the client, discuss their business objectives, what could go wrong. I don't know how many times I have been with a client, started a new matter and just launched right in and didn't even discuss with the client what could go wrong. And I think this is a really important piece of communication, because otherwise, you know, the client doesn't even know what could go wrong. And then after the meeting, you're going to write a charter, a project charter. And the project charter really incorporates all the things that I've been talking about: budget, schedule, communication plans, you know, everything that you need to discuss up front. And I won't have time to go into an example project charter today, but then you'll have the client launch meeting, where before the meeting, you want to meet internally with your client. and your team, rather your team, not with the client, if you have one, or just yourself if you're a solo, revise the charter, and during the meeting, review the charter with stakeholders. And the chart, it's really important to get everybody to sign off on the scope that you're presenting, the scope of the work, and make any revisions to the charter before you and get stakeholder sign off. So here's a sample communication plan. Rather than being reactive and not proactive in your communication, I think it's really important. I can think of it when I was like a teacher. Rather than calling parents when students did something wrong, I like to start off each of the 6 weeks with calls to parents praising their children. Then when I had something go wrong, I had earned both their trust and their child's trust, because the child knew I was gonna call for positive things as well as negative things. It's kind of similar to the client. I mean, at the beginning of a matter, it's great to establish when you're going to talk, and maybe you're even going to provide a one-page summary weekly, or even just an email weekly that's a status update on the case, or where you need their feedback and input. Other communication tools are internal meetings, dashboards, where I don't know how many of you have ever used a dashboard with your client, but it's pretty amazing to set up there's all these technology tools out there these days where you can really show the client where you are budget to actual. I know that's something that I had not done. I had not thought about, okay, this was the budget at the outset, and along the way, this is where we are. This is the realization rate that I'm actually attaining. This is the work in progress. This is the number of open matters that you have if you have a series of matters with the same client. Client meetings. Instead of just trying to play phone tag with the client, it's a great idea to set up a regularly scheduled meeting. And the frequency will depend on how involved the client wants to be in decision making. And it will focus on, it's a time to talk about any budget deviations, timeline issues, or scope modifications. And, certainly providing a progress report, a summary of what you've done in the past, what's upcoming, and any issues that could impact the case or transaction. So the next two strategies I'm going to talk about are alternative fee arrangements and how to get started with those. So note that we'll talk about both pieces of this and this strategy. The definition, well, I'll talk about what an alternative fee arrangement is in just a minute, but let's reflect again. I generally charge by the hour with an established budget at the outset. I know that's been my historical way of doing business. At times, my legal fees have surpassed my quoted budget for the matter. I could improve my ability to quote fees before a matter begins. Throughout a matter, I track the percentage of work I've completed against the budget. I know I never used to do this. At the end of a matter, my clients have requested write-offs or pushback on my final invoice. And this is definitely something that's happened to me, and I'm sure it's happened to you too. So an alternative fee arrangement, why should you do this? It's a pricing arrangement that is not based strictly on the billable hour. So what's wrong with the billable hour? Legal pricing experts predict that the billable hour will become the least used and most scrutinized form of pricing in the future. Hourly pricing will become the exception and not the rule. Big Law has been using alternative fee arrangements for the past decade. Well, what if my clients aren't asking for this? Why should I charge them, start using alternative fee arrangements now? Somebody's not on mute. I don't know who that is, but I can hear their sidebar conversation. If you fail to start working with alternative fees now, you're going to be left behind the competition, because Big Law is doing this. They've been doing this for a decade, and they're tricky. You can't master them right now. You're going to have to practice, practice, practice. And I'll get into what some of the example alternative fee arrangements are, and how to kind of some tips to get started with them. Certainly the fixed fee and strategy 4. So the benefits of alternative fee arrangements. This is a survey from LexisNexis, speaking different languages, alternative fee arrangements for law firms and legal departments. And this was done several years ago in 2012. And at that time, people were already, law firms, law departments were saying cost predictability and transparency, cost savings, increased efficiency, risk sharing, all of these things that I've been talking about. Attracting, and on the law firm side, you want to use alternative fee arrangements to attract and maintain clients, simplify billing and operations, and increase billing realization. So when you're thinking about the different categories of fee arrangements that you could use, what you want to do is consider the client goals, and also think about, the goals might be related to efficiency for the client. It might be risk sharing or cost predictability. So what do I mean by all of that? These are some example fee agreements, alternative fees. Whereas the cost this side over here, the hourly billing, that's the best way to go if you're the firm. But it's not necessarily the best way to go. Well, in not all cases. It's not always the best case for the client. And as the economic downturn that we're experiencing now, I don't know how long that's going to last, but I'm sure that your clients have been asking for greater cost of predictability. Risk sharing is where the firm and the client kind of share part of the risk. And outcome-based fees are where you're completely reliant on the outcome as a determination of what the fee will yield. So I'm going to go into a little bit more depth now on some different examples of this, and I would still love to see more shining faces. So a fee cap, just like what it sounds, fees are charged at an hourly rate until you reach a certain limit. And work that exceeds that limit will be finished at the firm's expense. So clearly on the firm side, you're assuming all the risk, and it really incentivizes you to bill as close to the cap as possible. But it does provide the client with a lot of certainty, and they like it. Fixed fees are probably the most popular. Another type of fixed fee is a menu of fixed fees where you break it down. You can use this in phases, so you don't have to price something out at the beginning for the whole year if you have a long transaction going or a long case. What you can do is use phasing and say for the first 90 days, or if there's a logical break potentially between discovery and trial preparation, break out certain sections of your work into the fixed fee arrangement. In a borrower side loan, for example, you may have to do the purchase and sale agreement. You may have to do the loan agreement and the ancillary loan document review and negotiation. The client may or may not, however, have a cash management system. So that you might charge more for that. You might charge a certain fee for corporate governing documents, drafting those, or certain opinion letters, depending on the type of opinion letter that they need, that might cost a certain amount as well. And for the client, again, budget certainty, this is what this is all about, the slide is about. And but if you're using fixed fee, it really promotes effective matter management on your end. I know that since I've started using them, I am more efficient, and I think my clients really appreciate that. Retainer, we've all heard of retainers, and they've been, I sort of thought of them as something that you used back in the day, but they're coming back and more people are asking for them. The client pays you at a fee, a certain cadence for specific scope of work. So that's where the first slide, the first section of this, the first strategy is really important. If you can't define what the scope of work is at the outset, you're not going to be able to provide any kind of retainer. These work well in trademark, portfolio management, and employment matters. They're also a great marketing tool for the firm because the client's picking up the phone and calling you all the time. And so if you have this option as something that you're willing to give to your client, they may give you more business because you're talking to them at a more regular cadence. The one thing that you have to be careful for is watching that scope. And what's out of scope of the presentation that I'm giving today is how to negotiate those changes with the client later. So you might have established a scope of work up front, but what is it that you want to, how do you change that later? And that's a huge piece of doing any kind of fixed fee or alternative fee arrangements, is figuring out that scope at the outset so that you can then, if there is anything that comes up that wasn't agreed upon up front, you can negotiate a change in fees later. The hybrid risk sharing alternative fees are, for the risk caller, that is an hourly fee with risk sharing above and below a limit. So here's an example. If you have a fee that you think is a matter that's going to cost between $10,000 and $12,000, just to keep it simple. If the fees end up winding up being less than that, like say they come in at $8,000, you would actually split the cost with the client and of the savings. So they would pay you $9,000. On the flip side, if you were to come in over $14,000, you would only earn $13,000 because you'd split the savings, you'd split the overage with the client. So clients like this kind of thing because it encourages you to be more efficient, and it can be adjusted by phase. You don't have to do this all up front. It's something that you can phase in and use in different aspects of your matter. Another kind of risk sharing hybrid approach between outcome and purely client predictability on the fees is a partial contingency or a holdback or success fee. I'm kind of lumping these all together, but they're very similar. So the fixed fee model, you would start out with a fixed fee, but then a part of that portion would be held back. You could also do an hourly based model where a portion of that fee would be held back based on the outcome of the case or the outcome of the negotiation. If you have a transactional matter that's really important to the client. So the firm, as an example, may receive 75% of the normal rates, and then at the end that's withheld. The 25% is withheld till the end. What it does is it really aligns your interests financially with the client's interests. But the thing here that's really important is to agree in advance on a set of criteria of what's going to constitute value. So if you're going to hold back certain fees, you need to make sure that you know how you're going to define that you're going to get that 25% at the end. Otherwise, it would be in the client's sole discretion, which is not advantageous to you. So here's an example of a case study with cost predictability and risk sharing. So I actually just attended this True Value Partnership Institute on Friday, and it talked about, they gave this example and I thought it was worth sharing here. So it was a client that in March, they're a large manufacturer, and they had increased discovery charges in their to the tune of thousands of dollars, tens of thousands of dollars in their case. And the pandemic hit and their operations were shut down. And so the firm said, well, what are we going to do? You know, how are we going to help this client along? They wanted to offer some cost predictability to the client so the client could update their own budget. At the same time, they wanted to acknowledge the client's cash flow concerns. So, you know, decisions could be made on a case-by-case strategy rather than the client being clouded by budget constraints. And they also wanted to show the client that they would be willing to put their own skin in the game. So what they ended up coming up with was a phased fixed fee for the remainder of the case. And they broke it into payment schedule that allowed the client to make limited payments in Q2, because that's when the COVID was really bad, increases over Q3 and Q4 into the next year. Another thing that they did to show that they had the skin in the game was they held back 25%. I mean 25%, and only had the client pay 75% of the fees. And if the firm got a successful outcome on the case, then they would win the 25%. All right, so the last kind of alternative fee arrangement is an outcome-based alternative fee arrangement. So the contingency fee is the classic personal injury type setup, which is you're probably pretty familiar with. It's hugely beneficial to the client, and it's not available in all jurisdictions, though as a caveat, especially outside the US. The reverse contingency is being used more widely in defense litigation matters. So it's really about how much you saved the client. So for example, the fee would be determined on if there was an original plaintiff demand of X and you ended up settling or getting a judgment awarded, you would take, the fee would be a percentage of the difference between that amount that was originally requested and what you were able to achieve. So it certainly incentivizes you to reduce client liability, and it aligns your interests with the client as you think about charging a certain amount of money based on a percentage of this difference. And value-based is certainly the last type of alternative fee. It's a little out there, but it's definitely worth noting. It's where the fees are based on the actual estimated value of the legal work that helps with the client's business objective. So, because you've often done work, I've done this before, where I've done some piece of work and I already had done it before 10 times, so I didn't have to spend as much time on that. So if I'm charging by the hour, that might not actually be as beneficial to me as the firm, but I would, you know, this is time independent. So whether it takes you 2 hours, 2 weeks or 2 months or 2 years, the fees would be the same. It works well in M&A deals and IPOs. It's really hard though for both the client and the firm to figure out how do you measure value? How will we decide what the fee should be? And so this is, you have to be really confident in the type of matter that you're doing this for. If you've done it many times before, you're more likely to be successful. The last example here, as in a case study, similarly from that same institute that I went to on Friday, The situation was a large tech company being sued by a non-operating patent holder. And the client wanted to fight back because they thought it was really, there was no merits to the case. And so the firm came up with a strategy that was pretty creative, in my opinion. What they did was they thought about the client goal, which was to, just get a quick judgment in favor and get the case dismissed and get the patent invalidated. So if the firm was successful, they got a success fee for getting the case dismissed. But they knew that there was a chance that they weren't going to get the case dismissed. And so they wanted that multi-million-dollar piece of litigation. They wanted that opportunity. So what they did was they said, if we lose on the motion to dismiss, and we want you to stay with us and not go to some other firm, because that could happen, right? And so since they were, in this particular instance, they were successful, but if they hadn't been, what they were going to do was give a credit for the litigation so they could get that work. So they were going to get credit for the original piece of work trying to get the motion to dismiss, apply that towards the litigation if they had to go into full-fledged litigation. So I thought that was pretty creative. And it's an example. So how do you get started with these alternative fee arrangements? So here's 10 tips. Start with what you know. A particular task, a service, an offering where you're well versed in the matter and you can control the time spent in the process. Alternative fee arrangements really make sense, and they're the most practical for discrete projects with finite, predictable length of work product, such as a patent or trademark filing, a state plan, corporate filings, some kinds of real estate matters as well. Use a fixed fee formula like the following. This is something I had not really thought about. I just charged $325 per hour, and I wasn't thinking about what are my direct costs, what are my indirect costs, what profit should I be charging for? I just had never thought about it, but this is exactly what they do in the construction industry. They charge for their direct costs plus their administrative costs and their profit. I'll give you an example of that in a minute. Use phasing. I can't emphasize that enough. Review historical data. Don't try this with a client that you've never worked with. And in fact, I would suggest trying it with a client, a B or a C client, not your A game client. Implement UTBMS codes. I had never heard of these until recently. I'll go over them more specifically in a minute. Only discuss it with certain clients. Once you've let the genie out of the bottle, you can't put it back in. I mean, the best reason to do it is if a client's asking for a discount. But business development is about moving relationships forward with the right people, and it may be useful to discuss alternative fees with all clients, but it's really a great excuse to understand what clients truly want and need. But be sure to stay clear of any client that you're not in fact willing to do this with, because you don't want to, like I said, open this can of worms, because they'll always ask for this. So that B or C client might be the good one to start with. Establish assumptions. So when going back to what I talked about at the very beginning, with assumptions, trying to kind of limit things into like 3 turns of the documents, or making sure you have that deal room set up at the beginning and all the documents are populated. Practice, practice, practice. You certainly can't get this right the first time, and you have to be willing to say, well, I might lose one here and gain one here. Use change orders. That's not something that's really in the scope of this presentation, as I mentioned before, but if you have a certain scope of work and you've outlined it very clearly at the front end, you should be able to say that this new tax matter came up, and I wasn't expecting it in an M&A deal, and this is going to cost more, or you know, there's a curveball that came in the litigation that you weren't expecting. And certainly manage the work. And we're going to talk a little bit more about how to manage work efficiently, and then the fifth strategy. So here's a fixed fee example, going back to my little lease update that I did. So now I'm talking to a sea of no faces, but I understand you're busy. I love Mark and Rayhan. They're giving me the love. Come on, some other people, turn your cameras on. Come on, I know you probably put your, you didn't wash your hair this morning or something, but anyway, so look how the same example that I gave before on the lease update. I just broke it out into how many hours of a range that I thought it was going to take. And you know, here's $600 to $1,200, you know, at a rate of $300. I just used it, you know, a straight rate $300 for this example to keep it simple. And I was able to come out with a price, but I used this formula. My direct costs, the range was 5,500 and change to 8,100. So I split that in half and I said, okay, 6,800, I'm going to charge that much as my direct costs. I didn't really know how to, you know, estimate that other than doing that. And then I added 10% overhead and 10% profit for a total of 8,190. So you see that I actually came out with a little bit higher, but I was completely transparent with the client on where I came up with this pricing and how this was going to all work. I showed this to them. I showed them the range of hours for each of my different cost work breakdown, and they went for it. And this is exactly the kind of thing that that the transparency is what clients are looking for. So I mentioned this uniform task-based management system. These task codes were developed by the ABA committee and the Association for Corporate Counsel in the 1990s. The original purpose was to classify subtasks and complex legal matters for e-billing. And initially the response was pretty lukewarm, and they kind of went by the wayside. But more recently, there's been a research, and the big law firms are using these task codes like crazy. And you can actually use them in Clio, which I did not know until recently, but you can actually use this to break down your matters into different sections. So I'm going to show you an example of the M&A codes. So these are the M&A codes, the UTBMS M&A codes. So due diligence, ancillary documents, financing, regulatory and specialty matters, antitrust, you get the idea. These are all the different aspects of an M&A deal. So these codes are the phases, and this is kind of the guidance, like what are you actually doing in this type of task. There's ones for litigation. I can show you one of the litigation ones. It's a little bit broken down just more simply right here. Let's see if I can get my computer to do what I want it to. So here's the litigation codes just set up by fact investigation, development, analysis, strategy, experts consulting. This is all at the case assessment level. And there's a pre-trial pleadings and motions level and discovery, et cetera, and so forth and so on. So if you start categorizing your time and your billing entries, you can start learning how much your time, how to categorize your time. How much is something taking? How much does discovery cost? How much do the depositions cost historically? And so this is something that I think can be really helpful. There's workers' comp codes, there's litigation, there's project, there's no real estate or just general corporate codes, but the project codes work pretty well for those. Counseling, bankruptcy, M&A, knowledge and management, intellectual property, expense codes, e-discovery, government risk and compliance. So all of these different codes have been developed over the last several years. UTBMS.com is where you can go for this. Let's see, some of the best practices that you don't want to get too detailed in the weeds on these if you actually started to use them, but basically the idea is you start using these and then you can actually figure out how much things are costing, and you can do better at your pricing predictability for your client. You want to categorize matters based on the type of case, size of the company, whether it's public or private, so you can start analyzing your data. So this is a whole thing that, like I said, Big Law is using, and it's something that you should consider. The fifth strategy, I don't know if you've ever heard of a Kanban board. I had not, but this came out of Japan. And in fact, Toyota was using this, and they had these big walls in their plants where they had a to-do, in progress, and done section. And so, and everybody that's in, all the workers, it's all color coded. And somebody said to me, well, what if they're colorblind? And I was like, I don't know. But this is a way that you can manage your own matters. You can use this for any kind of project. So here's a quick reflection on, self-reflection on your matter management. At times, the way I handle my matters is ad hoc and even chaotic. Certainly, I can relate to this. I have no way to visually see the due dates and process I use transparently. It is difficult to provide a report to my client accurately in real time as to where each matter stands currently. At times, the approach I take to managing my matters is stressful and difficult. And the approach I take to managing matters could negatively impact my financial metrics. So if I'm so busy and I'm not taking control of my matters, could that possibly actually be hindering my progress in earning fees and helping the client? So a Kanban board is represented in columns, which are organized from left to right. Tasks are represented as individual cards. Stages of the process are laid out in order from left to right. And you can use this board, and I'm going to show you an example, a practical example in just a minute, for any kind of aspect of your work or for everything that you're doing. So here's an example board. Not that, let's see. This is one that I just made for purposes of this, let's see, I'm not getting it on my, here we go. So this is a litigation board. You could use this for anything, really. So to do is over here. Oh, this is sorry, let me use the right one. So to do is over here. This is any litigation matter. I use the codes the UTBMS codes that I just shared you. Any litigation matter is going to have certain sections: a case assessment, a pretrial, pleadings and motions, discovery, trial preparation, settlement, appeal, etc. So what you do is you set up a card for each of the different aspects for each of your different matters. So I just made up ABC. So in this case, you've got ABC fact investigation. well, that might be due on a certain date. These cards open up. This is a group, this is a document, or I mean an app called Trello. And I'll share with you some other examples. There's one called Legal Boards that's very similar. And you can see that you can create a checklist inside. You can add the due date. You can do attachments. The benefits of this for your members are you can add if you have people on your team, and let's say you have some of counsel that does an aspect of your work, and you have another of counsel that does an aspect of your work. I know Jay does that a lot. If you're you don't have full-time staff, or if you have a full-time staff, then you might have other associates or whatever on here as well, and you can make sure that only those people can see your cards. So and then at the end, you move everything, the cards move forward to complete. So I'm going to go back to my presentation. They're highly visible. It improves workload allocation. It increases collaboration. It improves efficiency. You can see actually bottlenecks that occur on your board. And then you can start to improve efficiencies with that. It reduces time in your meetings because you don't have to go over everything. It's already on the board. It's flexible and versatile. It's easy to create, and it's easy to use and maintain. So here are the different tech tools that you could look at using, Microsoft Planner and so forth. These are all different ones that are used in like IT world, and I really like Trello, and Legal Boards looks like a pretty good one too. They're really also very easy to set up. Like it looks like a lot to try to set that up, but it actually takes no time, and it started saving me a lot of time once I did it. You can also use them just with Post-it notes, but certainly building your board is important, and keeping yourself organized. So the final strategy that I'm going to talk about today is conducting after matter reviews with the client after every matter concludes. I don't know how many of you have done after matter reviews. I know I didn't ever used to do this with my work in the legal sense. But what an after matter review is probably just like what it sounds. The purpose is determined lessons learned, the document, any templates, document modifications that you want to have for future matters with the same client, better processes, better management practices throughout the matter, how you can do it better next time. If you have a team, you probably should hold it internally first before discussing it externally with your client. And it's really just this simple: what went well and what could be improved. And a lot of lawyers, they just want to jump right into the next matter. I know I've been guilty of that in the past, but once you start doing this, you can really learn a lot, and it means that innovations and improvements, would otherwise be lost because you don't evaluate your performance. I mean, lawyers don't usually like criticism, but the Association for Corporate Counsel also has a list of questions that you can use in your matters, and they're very much tied to things in this presentation. What did the firm do that went well? How well did the client do? Evaluate the client, discuss what the client could have done better that would have helped you be more successful. How well did the team collaborate? How well did the team stay on schedule? How well did the team stay within budget? And the team can be the client and the attorney, or the client and or the attorney team as well, if there's more than one attorney. How well did the firm do against metrics, targets, and goals? Where did the firm succeed most strongly? What can be improved for next time? And how does this matter compare with similar features? If you've got other matters that you're working on, how could you do this? Other cross matter lessons learned that you could inform other work. So that the Association for Corporate Counsel is a lot of in-house legal teams, And that's they're really a lot of our clients, right? The general counsel of a company. So if you're a successful, and just talk about the Modern Lawyer Bootcamp for just 1 second before we wrap up and ask for any questions that people might have. But if you're a successful solo practitioner or leader in your small firm and you're forward thinking and you want to learn to optimize profitability, efficiency, and effectiveness, I mean, what I've talked about today is just kind of the high level overview, and you're seeking a different kind of CLE experience, this boot camp is like a group of attorneys that will be holding each other accountable, almost like a mastermind group, learning these techniques and tools and piloting them into their practice. It's time to take a look at potentially registering for this, and I'd love to talk to you if you're interested. I'm just going to take you to the website really quickly to show you where to go. Let me find it. I lost it. Oh well. Well, it's themodernlawyer.net. Here, maybe I can go to it from here. Yep. So if you go to the website, the home page, you just navigate to the boot camp if you want to learn more about this. I also do legal project management for hire if you are a bigger team and you would actually like to learn some of these techniques. The boot camp is probably the best way to go. There's 12 live virtual sessions, 8 CLE credits are pending, and 6 one-on-one coaching sessions that I would do with you on the 2 a month over the course of the 3 months. And then, there's really, there's a lot of programs out there for big law, but there's not anything like this for small law. These are the types of things that you would be learning, just really on the front end, how to scope a matter out and build a schedule and manage things efficiently. A lot of techniques on process improvement, as well as project management. So check that out and let me know if you're interested. And then this is something else. Let's see, my last slide. If you wouldn't mind, I'll put this in the chat. I'd be grateful. Just lost the slideshow, but I would be grateful if you would complete a 3-question survey for me, because I've never done this presentation before and I'd love to get your feedback. I know there's probably lots of room for improvement. The 3-question survey link, well, it might be easier if I have my PowerPoint back up. Let's see if I can get that up again. If it'll let me go backwards, probably not. Well, anyway, I'll forgo this if I can't find it. I don't know. I'm gonna have to fast forward through all my slides, but I guess I will. Thought I had it pulled up. Sorry, I've got like tons of tons. So are there any questions while I'm finding this? I just went through it and didn't get to it. Well, never mind. Forget the survey. Any questions? Okay. Well, thank you all for attending. I appreciate it. And if I think I've lost her. I know there was a woman that was going to put Kimberly was going to put the information for getting your CLE credit today. And I have that too, that I could probably pull up if she's not on anymore.
I'm here. I've put it in the chat.
Oh, okay, you put it in the chat. Awesome.
Mm-hmm.
Okay. Well, thank you, everyone. I appreciate you attending today.